Thank you, everyone, for joining us on this episode of the Law Dad Roy podcast. I am here today with the Director of Employee Law, Workers' Compensation Guru at the law firm, Andy Smith. And we're going to talk a little bit about workers' rights. But before we get into that, Andy, tell us a little bit about why you got involved in the law in the first place.
Well, I actually come from a long family of lawyers. My dad was a lawyer. My twin brother's a lawyer. All my uncles are lawyers.
You're identical twins?
Identical.
See, everybody wants to know that. Okay, so we never know who we're getting.
Right. So I actually used to have lunch with people that thought I was him, and I would have to tell him, you just had lunch with this guy in math. Yeah. He's like, they would literally come to my table and sit down and say, "Oh, how was that math test?" And then you would, that uncomfortableness of saying, "Oh, I'm not math." You just kind of. But the reason I got into law is I wanted to understand my rights, because if you don't understand your rights, you can get taken advantage of. And my why is I don't like seeing people getting taken advantage of. And I did represent Fortune 500 companies before I turned my practice over to helping injured workers, because I just want to help people, and when they're getting taken advantage of, I can help them. Yeah. So by way of background, I was born in Kentucky, went to the University of Kentucky.
Bluegrass.
Yeah, and I believe we're both Kentucky Colonels.
That's right, we are. We're both Kentucky Colonels.
So that was in 1999.
Okay.
I actually didn't come to South Carolina to take the bar. I ordered the books, studied in Kentucky. And then I moved down right after I passed the bar exam and started practicing. And that was in 2000.
So did you go to law school in Kentucky?
I did University of Kentucky.
Okay, so you went undergrad in law school there?
Well, I played a Division I sport.
Okay.
So,
what did you play?
University of Tennis.
Tennis. All right.
So University of Kentucky at that time had a top 10 in the nation tennis team. So those guys were all going pro. Yeah. So I was just at that one tier of Division I where I was good enough to play Division I, but I could be a tennis instructor, but I'm not going to go on the tour.
Okay.
So there was a school just south of UK, 20 minutes south of UK, Eastern Kentucky University.
Okay.
So I had majors in political science and English.
Yeah.
And then as soon as I graduated, went to University of Kentucky, and then I kind of did the straight through program. Started practicing law at 26.
Yeah. So you went to UK, you did law school. Did you know at that time what area of law you wanted to go into? I mean, most people don't, but did you have any idea?
I had only seen the personal injury because that's what my father did.
Okay. Was he was in Kentucky? Practicing?
He was in Kentucky practicing. But my uncle was the chairman of the Industrial Commission in Ohio.
Okay.
So I would hear some workers' compensation talk because my dad and we get together with family reunions. So that was always an area of interest for me. But unfortunately in Kentucky they had the tort reform. Yeah. And then so another good reason to move to South Carolina if you want to do workers' compensation.
Right.
So, and then that's really how I ended up here.
Okay.
And so
you took the bar in South Carolina, you passed, obviously, you started practicing law. Right out, you were on the other side of the V, right? And a lot of times for people, I mean, just explain kind of how that works, because I think a lot of times people think, oh, well, if you used to work for the corporations, then maybe your heart's not in it for the people. But a lot of times, when we're right out of school, we've got loans, we've got bills, and like those are the people that are hiring, sort of deal. So what was your path like?
When I first got out of law school, I didn't want my dad to have the burden of paying my student debt. Right. So I went to my dad and I said, well, the reason why I'm going to make money after law school is because I took 3 years out of my life and I feel I should pay for this. That sounds really great until you're waiting to see if you pass the bar. Right. And then, because if you don't pass the bar, those loans are coming due. Right. So I finished high in my class. So I went to a large law firm, Hainsworth, Sinclair & Boyd, and was practicing downtown Charleston, representing like Charleston County, Dick's Sporting Goods, PepsiCo, a number of Fortune 500 companies. And so I had a daughter after I made partner, and my long story short, I had moved up to Greenville. So I actually had my own practice for about 14 to 15 years. And it's kind of unorthodox for somebody who's just, has one or two attorneys to be holding on to Fortune 500 companies.
Right.
And so what you do on the workers' comp defense side is you see how, I've done it for 20 years. So, and I was the one that would help strategize, and I would put meetings together.
Right.
So unlike other people that haven't practiced in the defense side, I can see what's going on in the background.
Right.
I can get the temperament. I can kind of say, oh, they're moving, or they're a little nervous about this. And I know what makes insurance companies nervous. Right. So actually that's allowed me in my plaintiff's practice to really use leverage and pry the uncertainty that the insurance companies just don't like.
Right.
And so after... Well, I have a beautiful 17-year-old daughter, right. And then we did move to Greenville when my wife was pregnant, and then unfortunately I had a divorce and we moved back to Charleston,
right.
So I could be with her.
Yeah.
And then so I've been, when I moved back, I did do defense work, but the plaintiff's work, I went into an agreement with a partner in Greenville, right. That she was going to build the plaintiff's business and we would work off the defense business.
Right.
But, and I told her 3 times, my dad has tried to do this, and every time they leave.
Right.
And so the Supreme Court says you have a fiduciary duty to your partners.
Right.
So I literally came back from vacation and she said, it's not working. I'm like, what's not working? We never, so I found out she had she had some large value cases that she just split. So that happened right about so I was like, I'm moving back to Charleston. So I opened up, and again, that's not that easy with a statewide practice, right. To bring those corporate clients back. So I had a nice office on the water over Walpoo Creek, yeah. And was enjoying myself. But really before COVID, I was just, again, with the insurance companies, just tired of dealing with them. Right. So when I'm on the phone and helping these injured workers, I can tell them the magic language that might get them, for instance, what doctors love to say and prevent people from getting money. Oh, this is just myofascial, which is just a fancy word for a muscular injury, or it'll get better. And we really want people to get out of occupational medicine and into orthopedics and get at least an MRI, right. Say if they injured the back.
So you see what's actually going on.
Yeah. And then what they love to say is, oh, this is all pre-existing and this was here before that. But the magic word on that is, Doc, it wasn't hurting me before, right. But now it is. Right. Because in South Carolina, as you know, if you aggravate, accelerate, or exacerbate a pre-existing condition, it's a new injury.
Right. Call that eggshell plaintiff. You take the plaintiff as you find it.
Exactly.
Right? And I think a lot of people think, of workers' comp injuries and they say, well, I can still work. And that is one part of the equation. But there's a lot of different things that go into the workers' comp analysis, right? I mean, first of all, most people, I think, are confused because a lot of times when someone gets hurt at work, I'll always hear them say, well, I don't want to sue where I work. I don't want to sue my boss. I don't want to sue the company. They've been good to me. But that's not really what it is, right? We're not actually suing the company.
It's not a lawsuit. And truthfully, if you have a workers' compensation claim, your employer is going to want to have a resignation and release after the workers' compensation claim. Right. Because, again, if you aggravate, so if you have a bad back injury and you're on work restrictions, and we get a really good settlement, they don't want to inherit another injury.
Right.
So they'll do a resignation and release in that instance.
If you're in manual labor and you've got a bad back, it's just sort of a matter of time. Is that the thinking?
Exactly, yeah. That it's going to happen. And they do treat, and they do make it uncomfortable after you file a workers' compensation claim, especially if you have work restrictions,
right.
And you're at work. Because you may be having a sedentary position and other people are working around you, right. And the bosses are they try to make it uncomfortable so you leave.
Right.
And the worst thing you can do is leave.
Right.
Because I can't get those weekly checks started up for
Right.
you. So if the employer doesn't have light duty work, just please stay there.
Right.
And then if you're being asked to do things that you can't do, when we get back into the doctor, we let them know, and we get an order from the doctor changing the work restrictions.
Right.
But
and the flip side of that, I mean, really, because the alternative is if you don't make if you're injured at work, you don't make a workers' comp claim, and you just try to keep working, but you're unable to work at the same level. I mean, South Carolina, at least, is an at-will state, so you can be, let go if you don't make that claim, right?
Unfortunately, the people that try or love their employer or are worried about filing a workers' compensation claim are the ones that get hurt the worst.
Right.
Because one of the things, as you know, the medical drives the workers' comp. Right. And what the defense will do is, okay, so you have a date of accident on June 4th, and you say, oh, my back's a little sore, and you don't report it to your supervisor. No, please report it to your supervisor.
Right.
So you go home, and next day it's a little worse. And you tell your supervisor, I'm going to try to keep working. But each day you're not going to the doctor and telling them that you injured yourself, you're hurting your case.
Right.
And then say you have 2 days off from work, and then you report it on Monday because it got really bad. Well, then you're almost like a week out,
right?
And they're saying, oh, and the defense is, okay, what did you do over the weekend?
Right.
You could have injured yourself, doing something over the weekend. So it's really important. And the employer is obligated to send you, and they have the right to control the medical.
Right.
So you should go to your HR department, and you should request. And when you go to the doctor, please tell them the mechanism of injury.
Right.
And a lot of them don't say it's work related, just for the very reason that you just said, that they're worried or they really like their employer, right, and they think it's going to get better. But sometimes it just keeps getting worse.
Right. They think the employer is going to get in trouble, but that's not really what it is.
It is not. It's not even a lawsuit. And
right.
That's what I have to explain. It's a claim, and
right.
They cannot fire you for filing a workers' compensation claim, or that would be a retaliatory discharge claim,
right?
And then you'd have two claims.
And they're not. And in any event, I mean, isn't it true? They're not paying the claim anyway. It's insurance that they've already paid for.
Correct. So, but a lot of my Fortune 500 companies were self-insured.
Right. Sure.
So
they're in those cases they're paying the claim, but when we have a small local business or whatever, I mean, they generally are going to have the workers' comp insurance, right?
Exactly. So a good example of what you're talking about is it's the insurance money, not the employer's money. Is one of my self-insured clients. It was literally a finger claim, right. And we couldn't get it resolved, and so we were going to trial, and 5 representatives from the self-insured employer showed up. So that's their money, obviously. So on a finger claim, and I had to tell those guys, please leave. Just keep one representative, or they're going to think this is a bigger claim than what it is. Right. So yes, when it's their money, they're really concerned. But it's very hard to be self-insured in South Carolina. There's tons of provisions, and you have to go through all kinds of regulations. So there's not very many self-insured employers anymore.
Right. And if you have, what is the threshold for whether or not you have to have workers' comp insurance? It's a certain number of employees, or how does that, how that works?
There are a number of exemptions for like agricultural workers and things of that nature. But normally if you employ 4 or more employees on a regular basis, they should have workers' comp insurance. And what employers love to do, and I think they understand it, some don't, but they 1099 these folks.
Right, independent contractor, right?
Yes, so they think just because they send them the 1099 rather than a W-2, that automatically makes them an independent contractor. Right. So I don't employ 4 or more employees, but I do have a lot of independent contractors. Right. Well, they don't understand the law determines what's an independent contractor, not what they put on the form. Right. So you start asking, do they have the right to hire and fire you? did you use their tools?
Right.
And you
right.
start going through the 5-prong test.
Right.
To determine,
and you realize a lot of these people are not independent contractors.
Surely not, and that happens in the construction business frequently.
Yeah. So when you're looking at a workers' comp claim and you oversee all the workers' comp claims here at the firm, what are some of the things that you see most often that people have done or not done that mess up their claim?
Really, that reporting, as you know,
Okay.
is the big issue. I call it getting their train back on the tracks.
Right.
And what I actually do is I stay in the background for the beginning.
Right.
Because I know from being a defense attorney, as soon as somebody gets an attorney, I would question that.
Right.
And then things would slow down. And they're not getting their medical treatment. Things start getting investigated. So
right.
what I'll tell them is I'll just simply stay in the background. And we can use the magic language
right.
and through the doctor's appointments. And what I'll do is I'll wait till they actually reach almost where the doctors say they're as good as they're going to get
right.
before I pop in.
Right.
So the biggest mistake they make is not having an attorney and not understanding the process at the beginning because they get derailed.
Right.
And so I can stay in the background and I'm saying, okay, this is the issue. Because again, I get the temperament. I know what's happening.
Right.
And it could just be a simple issue that is keeping their claim from being accepted. And then, so you don't necessarily want to cause that friction in the beginning. So we get the claim accepted.
Right.
A lot of attorneys like to go ahead and file and make a representation and the kind of chest pound.
Right.
That
doesn't really work.
It doesn't really help.
And in workers' comp, I mean, you said this earlier, but it's a little bit different because in a normal injury claim, if you're injured by someone else as a car crash or slip and fall or whatever, you get to pick where you get your treatment, you get to pick how much treatment you need and all of that sort of thing. Workers' comp is different. Explain how that works because it's very peculiar.
Yes. Okay. So as far as report the claim immediately, and what they're going to do is the employer has the right to control the medical. So what they're going to try to do is they're going to try to keep you in occupational medicine. So they're going to, I call it a doc in a box,
right? Like
an urgent care or
right.
something of that nature. And what they're going to try to do
just to say it's minor. I mean,
they're going to say it's minor,
yeah.
and what they're going to do is keep you in as much physical therapy as possible.
Right.
And normally, so that is their goal: is never get out of occupational therapy. Don't get in any diagnostic studies,
right.
And it's a strain or a sprain, and you're coming back to work.
Right.
Because workers' comp pays for the functional loss of use of a body part. So if they keep it just like a soft tissue injury, or an aggravation that was only temporary and not permanent, then they can say, okay, we don't have to pay you any money.
Right.
So those weekly checks we were talking about earlier with the medical is so important that the employer after 150 days can't stop those checks without an order from a judge, except if you don't attend your medical appointments. So if you don't attend your medical appointments, they're going to stop. Yes. And one thing a lot of folks don't know is they do provide transportation, and they'll have to provide a translator too if necessary.
Right.
So if somebody's car is broken down, they can't get to the medical appointments, just let me know. I'll get with or right. Get with the adjuster and we'll get them transportation.
Interesting. So, a lot of people, when they're injured at work, they say, well, it was my fault. I should have known that, that, just an example, that saw didn't have a blade cover because it never has, sort of deal, right? And so in a normal tort case, we would be looking at whose fault it is. But in workers' comp, we're really not, right? We're not.
Right.
Explain how that works. So I think there's a lot of misunderstandings about that part of workers' comp.
Okay, so a long time ago, around the turn of the century, there was a compromise. And what the legislature essentially did is created a judicial branch of the workers' comp system separate than like a regular jury trial.
Right.
And the reason why they did that is because they wanted to take negligence out of workers' compensation, because you have a hurt worker. Say they cut off or
Right.
they amputate their hand, you don't really want to be sitting around waiting for a jury trial to see who's negligent. So they made it strict liability, which means it's a no-fault system. Would you believe in South Carolina, if your employer provides safety gear and you don't wear it, it's not an affirmative defense?
Really? You
Yes.
can still make a workers' comp
You
claim?
can still make a workers'
Because it doesn't matter whose fault it is.
It doesn't matter. Right. And so what they did is essentially say, okay, it's a no-fault system, but then the employer had to get some things as well. So the employer, their liability is capped.
Right.
And certain things of that nature.
Right.
And they get to control the medical and things of that nature. So it was really a give and exchange for trying to get these folks in and get the medical treatment as quickly as possible.
Right. And that's really the goal of the system, is to get people treated, try to get them better and back to work, right?
Exactly.
But if you can, to provide for them.
Exactly.
Yeah.
And it's, you can always get work restrictions put on you, because a lot of things, as far as the money wise and workers' comp, if you have the work restrictions and the doctor releases you with the work restrictions at MMI, you may have you can continue doing those physical therapy exercises at home.
Right.
You can go get a physical, and those work restrictions might just be released, and you can go get any job you want to in the future.
Right.
But in the midst of the workers' compensation claim, you are under those restrictions, and that means money, because that precludes a lot of other jobs that you may have had in the past.
Right. And so that, but some of the things that you can't get, workers' comp, you can't get punitive damages. Right?
Correct.
Okay.
But you couldn't get, you could go into the tort system if it was an intentional act from the employer.
Because that would take you out of workers' comp, right?
Yes.
So we look at some of those factors, in particularly egregious cases.
Exactly.
And from time to time we have people say, well, I really suffered as a result of this. How does that work? How does emotional damages kind of play into workers' comp? Because when you say MMI, just for people, that's maximum medical improvement. So we're really looking at, okay, can you use your hand? Can you use your finger? Right? I mean, those are kind of the touch points for that. What is the emotional part like in workers' comp?
Okay, so the emotional part kind of overrides where the money is, because we want to focus more on the functional loss of use.
Right.
And if we're focused on the pain and suffering, and if we just go to a doctor's office and say, I'm paining or I'm hurting on my left side, they're truly not going to believe you.
Right.
So I would take try to take the emotion out of it, and obviously you hire us to get an objective perspective, because you're in a subjective position, and just call and we'll talk. But what you need to do, if you have some things that you want to talk about emotionally, just call me. But what the doctor does is, we all know they put 45 minutes on the medical note, but they're only in the office for 10 to 15 minutes. So the most important thing is not focus on the emotional aspect, especially in your doctor's office, but be very articulate with your doctor. Tell them where the pain starts and extends to, whether it's aching, throbbing, stabbing, burning. And the more detailed you are, the more the doctors are going to say, we might need that imaging study.
Right.
So I would, unfortunately, that is just one of the give and takes of the workers' comp system. So the emotional aspect, because it doesn't pay for the pain and suffering or the punitive damages.
Right.
So.
And in workers' comp, I mean, we really want the imaging study, because it takes all that subjectivity out of it, right?
Exactly.
It shows exactly what's going on. And if you're not actually injured, it'll show that too.
Exactly. And the commission pretty much, if it's not just a break, or a fracture or something like that, they're going to consider a medically complex case.
Right.
And so you have to obtain an opinion from a physician within a reasonable degree of medical certainty, more likely than not,
right.
what their impairment is, what their work restrictions are, and you have to present that to the judge
right.
to meet your burden of proof.
And so a doctor assigns that number.
Yes, and so that number is assigned, and that's why we really focus on whether they're having, if it's a hand injury, grip strength issues,
right.
range of motion issues, or if it's finger, because your finger's not worth that much, but your hand's worth 185 weeks. Right. So what the doctor...
And what is that? All right, so you just use the term, your hand is worth 185 weeks. Explain to people what that means. What does worth 185 weeks mean?
Okay, so... a week, think of that as an average weekly wage at 66 2/3 equals their comp rate.
Okay.
And that is...
So if I make, let's just, for ease of math, my average weekly rate... Okay. Well, no. Well, let's just say average weekly rate's $100, which obviously, is not. But let's just say it was $100. What you're saying is... 100% of that under the workers' comp schedule would be $66.66.
Exactly.
That's the most you could get if your average weekly wage was $100.
Exactly. So I guess we can talk about how to get the money.
Right.
Okay. So your hand's worth 185 weeks, arm's worth 220.
Okay.
Two most expensive ones are your shoulder is 300, your back's 300, your legs 195, your foot's 140. Then they have other different regulations for other different body parts.
And who came up with that?
The legislature came up with 42.930, but they did put a provision in there allowing the commission to make a regulation for different organs and other body parts that they didn't list or itemize on 42.930.
Okay.
So,
because it seems to me like in some ways it would be job dependent, right? I mean, if you are, let's just say, for example, you're a typist. Well, your shoulder or your back is actually probably a little bit less important than your hands in that case, but this regulation doesn't take that into account, right? Or does it?
That regulation is actually works different than 42.930 because the regulation is almost like for the brain like 25 to 250.
Right.
So it's a range, whereas 42.930. You would look at 42.930 and say, okay, this person has, we'll stay with a hand injury. 185 weeks possible. But you're going to be limited to that 42.930, that scheduled member provision where it lists everything down unless you injure two or more body parts. So that's why it's really important when we talk after these doctor's appointments.
To describe everything.
Yes, because a lot of times people have like a knee injury.
Right.
Well, that's going to create altered gait, which is just a fancy word for, you're going to be walking a little bit funny. Well, you might start putting more pressure on your left leg.
Right. Or your hip.
Or your hip. Right. And especially people that are, right hand dominant, if you injure your right upper extremity, you could start having left shoulder problems. And again, the shoulder is the most expensive body part. And you could injure your shoulder. And so that it was a case, Singleton, that said, okay, if you don't injure two more body parts, you're stuck with the scheduled member. So my goal is to get everybody off that scheduled member provision.
Right.
And I want to get them either into 42.910, which is the general disability, or I want to get them into wage loss, which is 42.920.
Okay.
So at 42.910, the general disability allows for the maximum of 500 weeks. So that would be times the comp rate times 500 weeks.
Right.
That would be your max if you're found permanently and totally disabled.
Right.
The only exception in that statute for that is if you're paraplegic, quadriplegic, or physical brain injury, and then those get in the millions because those are lifetime damages.
Yeah. Okay.
And then that's where we try to get you over there. And then in those cases, we get independent medical evaluations. And our folks, reaffirm what the defense physicians had indicated. They might make more restrictive work restrictions to preclude them from going back to work. And then we send that information all over to a vocational expert that says, hey, with all these work restrictions, I don't think this person's going to be able to go and find a reasonably stable job in this area. So I think he's permanently totally disabled. And then so that's when we go for the 500. And then but a different case scenario is we know the commissioner's not a commissioner. Since we don't have jury trials, we just have administrative law judges.
Right.
And so they preside, and so it's basically a judge trial. And if we know that going into this person's had the prior jobs and can work prior jobs, and it's not a permanent total disability situation, then I start looking at wage loss.
Right.
Because what you can do is if they're only able to make, X amount of dollars now, and they were able to make Y amount of dollars, you get 66 2/3 the difference over 340 weeks. So
in addition to your injury,
all your medical paid and everything.
Yeah.
And so a lot of attorneys don't use that statute, and that math really adds up.
Right. And the goal with any workers' comp case obviously is to make the person as whole as possible, right? And we're already at a disadvantage just by virtue of the system, because you talk about the most you can get, even if you couldn't use your hand, you couldn't work, is 66 2/3 of what you were making before. So you're already getting a discount, even if you get kind of everything you're entitled to. So that's where this wage loss or general total disability comes into play, to try to get people closer to 100%, because that's something that was given up in the statutory construct. Right.
You're exactly right. The system's set up to try to make you whole, to put you back in the situation where you were before the injury.
Right. And so one of the things that you mentioned was this concept of wage loss. Obviously, you can get more. Obviously, if you're quadriplegic, paraplegic, you have a brain injury, those things are we can see those things, we can perceive those things. We can get actual diagnostic data to say that that's true, to make that claim. But really, what I'm hearing you say is it's really in the middle, where people don't know what the statute says, right? So in your example, they have a knee injury and they say, well, my knee hurts, and they just keep going to the doctor over the knee. But then over time, the left hip starts hurting, and they don't ever mention that because they relate that to the knee.
Exactly.
And that's when so when you're talking about, well, there's some magic language, it's really just being fully descriptive is what we want people to do.
Yes, it's not any kind of trickery.
Right.
It's the stuff to get your train back on the tracks.
Right.
And so that magic language is not something, it's just a way or a means to articulate yourself so you can get your train back on the tracks.
Right. And these doctors, I know that in full disclosure, I don't do workers' comp. That's your area here at the firm. We know that. But these doctors that are hired by the employers, is there anything peculiar about them? In other words, it seems to me, at least, just from talking to you and sort of other people that do this, there's a little cottage industry in medical workers' comp, doctors. And, so when you're talking about, well, we want to get people independent, medical exam, we want to get them to our, people that we know to look at it. Explain a little bit about how that works.
Okay, so the insurance defense attorneys are so scared and that they're going to lose a client. So they typically probably have about 5 to 10 major clients. And if they mess up, that's over hundreds of referrals over the years that they could lose.
Right.
So what you'll find is about every defense attorney will use the same doctor in the same area, so that way they can't be found at fault if the doctor goes, and says this person, needs a spinal cord stimulator, and then you're looking at, permanent total disability case.
Right.
So what we do is we've compiled a list of providers over the years that are fair.
Right.
So if we don't think that our client got a fair shake by one of the defense attorney's doctors who provided a lower rating, didn't send them for a functional capacity evaluation where they test your grip strength or things of that nature to get a higher impairment rating and things of that nature. We get all the medical records together and we just send them over to the doctor and we schedule an appointment for them. And then that doctor will make an independent medical evaluation.
Right.
And that opinion can control just as much as the defense attorney's position.
Right.
And so
you just have more data points, really.
Exactly, and we use credible folks because you have to have those because the commissioners know some of the physicians will say anything, and same with the defense.
Right.
So there was a doctor in Columbia that the defense had to stop sending everybody to because he just gave everybody a 0%, even if they did a 3-level fusion.
Right. Only have one number on the keyboard.
Yeah.
0. So the you mentioned a little bit about trial going with these, in front of the commissioners and they're making a determination, and what percentage are going to trial versus a settlement? I mean, are most of these cases resolving, in a fair range, or are a lot of them actually going to a hearing?
With a lot of seasoned attorneys, it normally reaches mediation.
Okay.
And they implemented mediation probably about 15 to 12 years ago.
Okay.
Before then, I was in court literally maybe 6 to 5 times a day. I remember I had 5 oral arguments in one day because you were just constantly going to court.
Yeah.
But now that they have the mediation structure, when you go to mediation, it's always an uncomfortable feeling because you're worried if you're going to leave money on the table.
Right.
And if you're thinking you're going to leave money on the table, I put myself in that situation. What would I do? Would I want to take because you are taking a risk because it's a judge. You don't know if his
good day, bad day,
basement got flooded,
right?
Or his kids stayed out too late, or you just don't know what kind of temperament. So and that's an all or nothing decision.
Right.
Whereas in mediation, the client gets to make the decision, an informed decision, and you tell them and you advise them. Because I literally have been practicing before all these commissioners been on the bench,
right? And
they're the same commissioners, and they're the ones that have been trying cases in front of them. So I know what they're typically going to award. Right. And so if I think we can get more at a hearing, we'll definitely go to a hearing. But what I've found is the defense attorneys, if you keep prying them, they're trying to save defense costs.
Right.
So on a percentage-wise, most of them do not get to in front of the commissioner.
Right.
And one of the problems we have right now is we do have a conservative commission because obviously we have a Republican governor who appoints the commissioners.
Right.
So, and when we had a Democratic governor, the workers' compensation system, I think, worked much better for the employees.
So not a lot of trials, a lot of mediation.
Yeah, not a lot of trials because one of the reasons they started the mediation because obviously they wanted to get to trials quicker, but we were having so many trials. Yeah. It was like, why don't we just have a trial with the jury? Right. Because I mean, it's a year out. Right. Right. So they were like, hey guys, try to start resolving this stuff in mediation to see if you can't get clear our dockets. Right. So if we
especially with COVID, things were slowing down.
Exactly. Yeah. For sure, 110%. If we're not getting enough money, or if we think we're going to shortchange, let's go to court.
Yeah, 100%.
Yeah.
Well, Andy, I appreciated it. It's great to get together, have this conversation,
Thanks so much.
We'll have you back on soon.
Sounds great.
Great.
Appreciate it, Roy.
Thanks.